Welcome to this HIS 4470 lecture, Legality and Ethics. Legality differs from ethics. Legality is narrower and concerns avoiding doing something wrong. Ethics is broader and concerns doing what is right. This is to say that legality guides us in, quote, doing no harm, unquote, while ethics leads us toward actively protecting and even enhancing the benefits of others. So let's explore a little bit. Following Yao, I'll discuss legal issues surrounding copyright, contracts, libel and slander, and privacy first. Although Yao places institutional review boards in her chapter on legality, I'll discuss IRBs as an ethical issue. Copyright law is a mess right now, largely because the Millennial Copyright Act is a significant expansion of the law. The most salient point in the law as it applies to oral history is that it grants copyright for 70 years after the death of the copyright holder. But the law has yet to be sufficiently litigated, so we don't know yet exactly what the boundaries are. However, oral historians have some guidelines. First, copyright applies to the fixing of words onto a medium like a computer file, paper, or audio tape. Second, understand that most copyright actions do not result in a lawsuit. There's just not enough money involved to make it worthwhile. Rather, if you publish an interview to which an owner objects, they will inform you and you should do what you can to remove it from circulation. Sometimes you might get a letter from a lawyer, and you should make every effort to comply and let them know you are attempting to comply. If you believe you are in the right, however, you have the burden of proof in proving that you have an interest. The best way to protect all parties is to execute various forms of contracts. Some of these are release forms and gift agreements. They're between your project and the narrator to whom the copyright adheres. Release forms are between you, the interviewer, and the narrator. They are expressed agreements in which the narrator assigns rights of access and use to the interviewer. This applies for themselves and their heirs and assigns, so no one can come after you when the narrator dies. Gift agreements are between you, the interviewer, and the archives where you've deposited the interviews. You transfer ownership and copyright to the archives so it can use and make the information in the interviews available for research. To be on the safe side, I suggest you ask your narrators to execute a gift agreement with that same archives, in addition to executing the release form with you. Just like narrators can negotiate which rights they give to you, you can negotiate which rights you give to the archives. But beware. The archives can refuse to accept your gift if it doesn't like the conditions you impose. One of the most difficult problems that archives and some oral history projects that are not yet in the archives encounters are called orphan interviews. These are recordings that have no release forms or gift agreements. Does copyright law provide relief in such situations? Yes. But you must seal the recording for 75 years after the narrator's death. This seems like a high burden, and it is, but unlike the copyright laws of old that were meant to provide an individual author a short time to monetize his or her work, this new copyright law is designed to grant a monopoly to corporations in perpetuity. In fact, it was the impending end of Disney's copyright over Mickey Mouse that led Congress to pass this latest version of the law. Copyright law continues to evolve. Contracts like release forms and gift agreements supersede copyright law, so make sure that you execute them correctly. Libel and slander are other concerns among oral historians. While slander applies to the spoken word and libel to the written or fixed word, both concern defaming the character or the reputation of a third party. That is, slander and libel are acts of slagging on somebody else. In oral history interviewing, where does your liability come in as the project director or the interviewer? When the narrator slanders someone, isn't that their problem? Indeed it is, but it's also yours, at least according to court rulings against previous people who repeat or publish the slander or libel. In the United States, though not in England, truth is an absolute defense against a charge of slander or libel. Also, slander and libel can only occur against a living person who is not a public figure, though public figure is a little bit fungible here. In addition, the person must be identified specifically, they must be able to prove that their reputation suffered, and the person or plaintiff must prove you intended to do them damage. These are pretty high bars to clear, but you don't want to test these in court. One of the best ways to deal with potential libel in an interview is to make an access copy of the interview and transcript with the offensive words silenced or redacted. These become what the public sees until the confirmed demise of the person being libeled. Once that person dies, you or the archives replaces the redacted copies with the original. This is similar to how the government might declassify a document. The full version replaces the redacted one. The issue of privacy segues from legalities into ethics. There are, for example, laws to protect a person's privacy from secret recording, though in some jurisdictions only one party to the conversation has to know about the recording. This is actually to prevent third-party spying, but it does not prevent an interviewer from secretly recording a narrator. In that case, this act crosses into ethical territories and indeed is an ethical violation. There are, in fact, few laws that apply to oral history concerning privacy. Yao discusses privacy and focuses on releasing intimate information that might subject the narrator or others to sneers or ridicule, or even worse. While there is little case law that defines the boundaries of this kind of violation of privacy, you might be committing a tort for releasing it. That is, a civil action can be brought against you. Regardless, if you release overly intimate information that embarrasses the narrator, you will have damaged that relationship and any that spring from it. Also, you will have violated your ethical responsibilities toward that narrator. Your project may be only about gathering interviews, and the end product is the interviews themselves, whereas Yao wrote works using her interviews as evidence. In her case, she could choose what information to disclose. In your case, and in the case of the archiving of her own interviews, you and she should consider working with the narrator to silence certain sections of an access copy, or redacting parts of the transcript of the interview until sometime in the future. Be sensitive to the damage this kind of intimate information can cause, even when the narrator brushes it off. Now, like I said, privacy spans the analytic divide between legality and ethics. Remember, where legality concerns do no wrong, ethics demands that we enhance the benefits that accrue to others. In our case, these others are the narrators. Yao wrote, and I agree, that Immanuel Kant's moral imperative applies here. Treat people like ends in themselves, not as means to your own ends. People themselves have values and rights that you are obliged to put first. When applying this to oral history, your best guide is the Oral History Association's Principles and Best Practices Statement. First and foremost, ethics recognizes that there is a power relationship between you and your narrator, and it seeks to prevent abuses, even inadvertent ones. But good ethical practices require more. In practice, you must, quote, put the individual's well-being at the center of your decisions, unquote. And that's from Yao's third edition, page 160. You have to take care to both prevent damage and to enhance the benefits to the other person. Remember, however, that you also have a responsibility to truth with a capital T, as well as to the narrator. Your post-interview products should not be mere happy talk that sugarcoats a person at the expense of that truth. Finding a balance is a matter of experience and good judgment, informed by a thorough understanding of ethical guidelines and codes. Luckily, you're not likely to run into too many situations in which you have to make hard choices between the well-being of the narrator or others and fidelity to truth. That might occur later, but in this project and early career projects, you're not likely to really be digging around all that deeply. Only once in my oral history career have I ever had a narrator pull an interview, and that was because she had just lost her husband and was overwhelmed by seeing a raw transcript. She was much more concerned about the transcript making her sound like a buffoon than with her recounting a war crime her mother committed in World War II England. She relented after a while, and after she saw an edited transcript. The rules of speaking are different from the rules of writing, and the raw transcript, which captures every and ah and every misdirection, made reading very difficult. You will hear much about informed consent, the notion that the narrator understands the nature of your project and the uses you and others will make of the recordings. This is often problematic, for no one knows what will occur in an interview before it takes place. This is why I advise that you provide the narrator with a draft of the release form before the interview so they can read it and become familiar with it, but that you wait until after the interview to ask them to sign the release form. You must explain as many aspects of your use of the interview as you can, and look out for your narrator's interests, even if that person does not look out for their own. Remember that narrators have the right to refuse to participate in the interview or sign the release at any time. They even have the right to withdraw consent at a later time. You cannot pressure them. You cannot make them feel bad should this occur. You do have the right to discuss this with them, though you should wait until they've had time to distance themselves from their rejection or withdrawal. Sometimes, as in the case that I just talked about, a narrator will reconsider and restore their consent. As a direct consequence of the notorious Tuskegee syphilis experiment, Congress created what's called the U.S. Office for Human Research Protection. Any institution that receives federal funds and conducts research must establish its own institutional review board called an IRB to monitor and guide researchers in protecting human subjects. The law and IRBs are aimed specifically at medical-like research, but mission creep and a heightened sense of responsibility led many IRBs to include oral history on their list of project types that must apply for permission to proceed. Now, this has gone back and forth over the past decade, and at this time, oral history does not fall under IRB purview. Nevertheless, we should be aware of the guidance that the IRB offers regarding informed consent. And this is why I've asked you to take Troy IRB training and take the applicant's quiz. Thank you very much for your attention. This concludes this lecture.